Here we are, impact on your estate planning on our legal updates. So officially welcome. We've gone through all the housekeeping things. Those of you who are here know me quite well. Most of you do. For those of you who don't, officially, my name is Kevin Snyder. I'm an estate planning and elder law attorney here in Irvine. I have my own practice. And if you guys are really knowing me and how we work, it's me and Carolyn that have the practice here. Because without Carolyn, without a wonderful team like Laura and others, there really is no practice. All right, it's like the cardboard person standing up. So I'm the cardboard person, but I have a lot of good knowledge. That's just happens to be a wonderful gift that I have, and I love talking about it. So I'm going to take this next time, this half an hour, to talk about these new topics. Back to who I am. So you already got diverted. I was talking about I'm an estate planning law attorney. What does that mean? That means that I help families plan to protect their loved ones, their assets, and their future with putting together these wonderful estate plans and helping families navigate the challenges of a death or an illness like a dementia. And so what we like to say here is we make difficult conversations easy. And so that's what I'm trying to do today, and that we're going to be talking about some difficult things that you might encounter in life and the laws surrounding them and the new impact that a lot of these are going to have. So get your pen and paper out, even though Laura's going to be sending this stuff to you. There's so much here. So we're talking about it at a high level. So I want to be able to make my time and hit these marks to get you the information. If you want a deep dive on any of this, I offer a couple things for you. Offer number one, reach out to us. If you're a current client, new person, and you have a plan, reach out to us and schedule a review. Happy to sit down with you one-on-one to do a review of your plan. So you go one-on-one, and then we can really deep dive how this stuff affects you specifically. So to do that, you're going to contact Lara at her office, or if you just pick up the phone and call her office, you'll get in touch with the right person. All right. So there's that. Go to our website, put it in the contact information. We'll get you all scheduled. The other offer, option number two, is if there's something that I've covered today that you just want to know more information about, and you said, hey, that would be great if Kevin spent 30 minutes on that, reach out to us. Reach out to Laura, go to our website, put it in and say, hey, I want to know more about this topic that you talked about. You know, all of these things I talked about today, I could talk for an hour or two on some of them, certainly 30 minutes more. And so what Laura will do is that she will put together another webinar for another Friday, and we'll deep dive on that topic. So happy to do that for you. So those are two options to learn some more beyond today. So what you're going to learn today is that you're going to learn these things here. These are our top 10 things that we're going to try to learn about. Like I said, I'm going to hit all of them here. So we're just going to let this sit for a second, let you digest this and sit in the presence of the moment and say, wow, this is kind of a lot. There's a lot of good stuff in here. So we're going to hit all these things. One caveat is number seven, Secure Act final regulations. I was working on that for today, and I said, you know what? I think this would be a great separate conversation for another webinar. So I'm going to talk about it, high-level stuff, remind you of the Secure Act, why it's important, but Laura's going to schedule a separate webinar on the Secure Act. So if you are interested in attending that, what I ask you to do right now is drop in the chat that you are interested and just say the word secure. And that will give us a good list. We'll make sure that you are on the list, the invitation list for this new webinar on the Secure Act. And we're not going to wait till Christmas to come out with it. This is literally something we're going to be doing in the upcoming weeks. All right, so go ahead and drop in the chat the word secure, and we'll get you on the list for that webinar. All right, so a lot of stuff here. So we're going to start with gifting. Why? We're going to start with gifting because it's fun. Everyone loves gifts. Who doesn't love gifts? So why start a webinar about legal stuff that might be a snooze fest with something dry? We're going to talk about gifts. We all like making gifts. So this is how you can make gifts this year without having to deal with the tax man or woman. So the gifts are, of course, money or things of value that you're going to be giving to somebody else that's not you. So value, oftentimes we see this in the form of real estate. So if you want to add a son or daughter to title on your house, that is a gift, because it's not just words on a piece of paper that get filed. It has meaning. It means you have transferred ownership of the house, in part to your child or whomever it is that you're putting on title. Maybe it's a new love interest, or it's another relative. Maybe it's somebody you feel forced to put on title because you're trying to do a refinance of your mortgage, and the lender says, well, we need somebody else to co-sign with you in order to make this work. And so because they're co-signing, they need to also be on the deed. So you're like, oh, we'll just put them on the deed. That's fine. Well, there's meaning there, right? So you've transferred part of up to half of the of your property over to that person. That is a gift, as much as it is, hey, it's your birthday, it's a holiday, special event, we're giving you money, graduation. There are a lot of people have kids, grandkids graduated, gave some money. That's a financial gift, a little bit easier to calculate. So this year you can do things, well, any year, you can do things to make those gifts tax-free. If you don't, guess what? The federal government's going to say, haha, we love your altruism. We love that you're helping people, but you have to pay a tax. And it's called a gift tax. So the gift tax is placed on the gifter, not on the person who's receiving the gift. So again, it seems like a disincentive to be making gifts. But that's the rules. So we're just playing with the rules. But the rules also say that if you make a gift of up to $18,000, then it's not going to be taxed. So you can make a gift up to $18,000 to one person every year, and that's not going to be taxed. And so you can make multiple gifts of $18,000. So it's just not one gift, it's per person. And if you're married, you can combine your gifts. In other words, you and your spouse can each give 18 grand to one person, one child, one grandchild. So really, married couples can give up to, do the math, $36,000. I was told there wasn't going to be math in estate planning, but totally wrong. In fact, I was told there's no math in law. And I think that was just a law school trying to convince me to go. And see, they pulled a fast one, and there's lots of math. So I did that pretty good. We're living. So that is the new rule. So you get an extra 1,000 over the what you had to do last year per person. And so you don't have to report anything. Wonderful. So no paperwork. Awesome. Little asterisk, gifts to a non-US citizen spouse. So we have a number of clients that are from Canada, Mexico, France, other countries, and they're here as legal permanent residents. They have their green cards. They're and they're married to a someone who is a citizen. Sometimes they're two people from other countries that are have their green cards, or they have some status here, work visas. They are not citizens, or there's a non-citizen spouse. So let's do the example of, we have husband and wife, and the wife is from Canada. So the husband wants to make a gift to the wife during the year. Has to be careful with what type of gift it is, the amount of the gift, because gifts are, there's a limit for non-US citizen spouses. It used to be $175,000. It's $185,000. Well, that sounds a lot better than that $18,000, sure. But if you are a citizen and you're a citizen spouse, so both citizens, then it's unlimited. So that is a big departure from if you're both citizens. So it's unlimited otherwise. Where is this impactful? Again, with real estate, we see it a lot. Now, you've bought the house. Maybe you bought the house before you were married. You get married to a gal from Canada. And now you say, you know what, I want to share this house with my new wife, who's from Canada, and I'm going to put her on title. Or, you know what, my wife from Canada has that extra income, and we need that income to qualify for a mortgage. And they're talking to us about we need the wife on title, so I'm going to put her on title, and now we own the property together. Essentially, you just gave half the property. That might be a taxable transfer, because let's say your house is $1 million. Now you just gave your Canadian wife, 500 grand. That exceeds the $185,000 mark. You're going to have to pay a gift tax on that, by the way, unless you file some paperwork with the IRS, and that's called a gift tax return. And that's what we're going to do in that situation, because we don't want to pay taxes making gifts to people. We don't want to be limited to making gifts to people. We want to make the gifts we want to make, especially when there are kids, grandkids, and spouses. We just now have to talk to our accountant, our CPA, or if we don't have one, get one. Don't do this yourself. I'm a big proponent of using professionals, and file a gift tax return. It's a Form 709, and you're announcing that gift to the IRS saying, hey, I put my Canadian wife on title. The house is worth a million, so her half is worth 500 grand. I got the appraisal, put it in with the paperwork. I'd like to put that on my tab, IRS. What tab? The tab that you have was your lifetime gift and estate tax exemption. So you have lifetime gifting ability to gift up to a certain amount in your lifetime, and the IRS keeps tabs on that. So think about it like you have this little club card from the IRS, and there's value on it, and you're just saying, hey, put the little chit in it. Well, punch that. I'm going to punch that amount on my club card, and now I have a little bit less of gifting power. So the gifting power is pretty tremendous, and we're going to talk about this in just a few minutes. $13.61 million per person. A lot of gifting power. That's assuming you haven't used it. That's assuming your club card with the IRS has no punches in it. And make no mistakes. If you know me, you know I talk in a lot of analogies. There isn't such a thing as a club card. So if you're sitting there saying, hey, I never got that from the IRS, maybe I need to go get it. You don't. It's Kevin made it up. It's an example. So I know you guys are all smart and you realize that, but I just want to be fair in these disclosures. So 13.61 million is going to go up again next year, and last year it was 12.92. So this is going to increase until it's not. So next year's the last year it's going to increase, and then in 2026, and this is what I'm going to talk about in a few minutes, it's going to decrease drastically. So let's put a pin in that part because we're not in 2026 yet. We're here, so you got this 13.61 million. You file the paperwork with the IRS. They put they punch your club card. You're good. No taxes are owed. So what have you done? You the inconvenience to you is having to fill out paperwork and paying the extra fee to your accountant to do that paperwork. All right, so it is an inconvenience. It's not much of an inconvenience, and of course, you have now less gifting power. My example with the amount that you have, that's not bad. You still have a lot left. Just you have to be aware of it, because if you don't do this, and then let's say you get audited by the IRS, so I have some people I talked to about this saying, well, how the heck are they going to know? They're not going to know. Yeah, that's true. It's not, if you don't tell them, they're not going to know. They don't have little IRS Alexas in your house listening to you. The way they find out is when they audit you because of something else, not because you're a bad person. There's a number of different reasons for being subjected to an audit. You get audited by the IRS and you have to give them all your paperwork or your tax returns, and they say, hey, what's this? You should have filed a gift tax return or paid taxes, and you didn't pay taxes. Well, guess what? We're going to charge you the tax. And this happened, 5 years ago? Yeah, there's penalties of 5 years slapped on top of that. So, and that's going to obviously be way more expensive than whatever money it's going to cost to pay your accountant to do the gift tax return. So, and it doesn't matter if you say, I didn't know about it. Nobody told me. There's no intent here to these civil penalties. It's just, did you do it or didn't you do it? You're supposed to do it. Did you not? And then if you didn't do it, doesn't matter if you knew you had to do it. You didn't do it. So they're going to hit a penalty. So I'm telling you now, so you're aware of it, so you can get in front of it. Other things that you can do to give tax-free gifts outside of this and preserve the value on your club card with the IRS, your lifetime exemption. If you're citizens, you can make gifts to your spouse, unlimited between each other, not a problem. You can pay for medical and educational costs directly to, if you are a grandparent and you have some extra funds, or you've been saving and you want to pay for your grandkids' school or part of it, you could make the payment directly to the educational institution, whether it's the elementary school, high school, college, make it direct to the actual institution, and that is tax-free. That's technically a gift. You're providing value to somebody else, but the government's not going to tax you for that. Same with medical costs. If you want to help out a family member paying bills, medical bills, pay the treatment provider directly, and then that's going to be a tax-free gift. You can also, don't want to get ahead of myself. You can also give up to $100,000 to charity annually from an IRA. That's could be helpful for you if you're in retirement mode and you have done such a great job growing your IRAs. And it's not uncommon. I meet with people all the time that have done a really great job. You're in that generation of where you were given lots of opportunities to save. It was more part of the culture, and you may have worked a job that has a pension. And so between pension and Social Security, you got enough income to live off of, and you really don't need that savings, but you're old enough now, you're 73, and you're forced to take out money out of the IRA. And you're like, shoot, I don't want to do that because I really don't need that income. And all that's going to happen is they're going to tax it as income. I really would just rather leave it alone and not touch it, but I'm not allowed to do that. I have to take it out. So I'm going to take it out and get taxed. Shoot, that stinks. I'm giving Uncle Sam money when I don't want to. So what can I do since I'm going to lose that money anyway with the tax? What can I do instead? Well, you can make a gift up to 100 grand to your favorite charity or charities, and it's going to be tax-free, and it goes directly from your IRA to the charitable institution, and there's no gift tax at all. So if you have large IRAs that are just sitting there and you feel like it's going to be just wasteful, pulling out income and getting taxed at an ordinary tax rate, which might be high for some of you, look to do these charitable gifts. Of course, other caveat, just don't do it because I'm telling you to do it. I'm telling you to think about it. All right. I'm not telling you to take action on this. I'm telling you to think about it. Go talk to your professional advisors. Some of you are our clients. Let's talk about it. Some of you are in our client care program, and that's great topic for conversation during our annual meetings that we're having now, second and third quarter. If you're one of our clients not in our client care program, and gee, that sounds nice, Kevin, I'd love to meet with you. Let's give Laura a call. She'll talk to you more about that. But if we don't know each other, you're not one of our clients, you have your own professionals, go talk to them, talk to your accountant about this, of course, above all. Okay, that's our segment on gifting. There's a lot there. I promise. I said I'm going to only hit this at a high level. Other things I'm going to spend a little bit longer on is on the Corporate Transparency Act. So for those of you that are business owners, or you've invested in a business, or you are a trustee of a trust that's irrevocable, or somebody has passed away and left you as a trustee for their trust, then you're going to want to pay close attention to that. So we're going to move away from gift taxing and give you an alert. Beware of the sunset. This is not the green flash. This is not something that's good, although sunsets are great, and that's a nice one here. And we're blessed having lots of great sunsets here in Southern California. We're talking about a sunset of that lifetime gift and estate exemption, that value on our club card. Our club card is going to decrease in value. So this is just like when any of you are in any sort of rewards points program and they go through this big change and say, we're changing our schematic of how we're doing the rewards program. And you're like, shoot, I kind of like the old one. And now they're going to make this change and decrease the value of this rewards program. And if you that have timeshares, know exactly what I'm talking about. That's just like that. So you have this value in the club card. It's 13.61 million this year per person. Guess what? January 1, 2026 is going to decrease down to approximately $7 million. 13.61 down to $7 million. I say approximately because the numbers aren't out yet. We know it's going to be cut in half. So we can expect probably next year's value is going to be slightly over 14 million or very close to 14 million. So that's why when I say it's going to be cut in half, it's going to be cut in half to about 7. Might be a little under in the 6s, might be a little over like 7.14. We will see when they announce those numbers in advance of that comes out in like December. So we'll know those numbers then, but we know it's going to be just about half the value. And so that's going to be problematic for some people. Why? Because now you don't have as much gifting power. And shoot, I could have gifted a lot more and I wasted that ability because now the value of my club card is less. Darn it. But of course, you have to have a lot in order to have that sort of conversation, have that darn it moment, because that's a lot of, still 7 million is nothing to sneeze at. And you get to combine that with your spouse. And so now you each have 7 million to give. So that's 14 million. And guess what? One spouse dies, you can take the unused part of their card. You can take their club card. So that's part of the inheritance. Here, honey, here's my club card. Boom. And anything that's left on it, you get to use and claim for you. So if you pass away now, then you leave your spouse their club card, and you haven't used anything on it, you're giving them 13.61 million value club card that's always going to be that. That's not going to get cut in half. And January 1, 2026. That will still be worth 13.61. So it's something we talk about when people pass away that we have to look at and do is make sure that club card, that gift, the estate exemption card is passed over. The unused amount is passed over, and there's paperwork that needs to be done. Doesn't happen automatically. While you have 5 years to do that, you want to do that right away so it doesn't get lost in the shuffle. And it's a very valuable piece of a very, very valuable thing to have. So like I said, it doesn't happen automatically. So if you are a trustee, you're a surviving spouse, and I'm talking to you right now, and you're a widow or widower, or you know somebody who is a widow or widower within the last 5 years that's happened, this is an important piece of information to take away. Did you, or did that person that you know, who's the widow or widower, did they fill out some paperwork with the IRS that allowed them to transfer the unused amount of their estate exemption from their spouse that passed away? Said plainly, did they fill out paperwork so that they can take over their spouse's IRS club card that they hadn't used? If the answer to that is no, then we need to talk right away. If the answer is I don't know, we need to talk right away. If the answer is yes, yay, you get a big high five. You did it. So now you know that whatever the value of that club card was that year that your husband, wife, or your friend, relative died, that's the value of the card forever and time. Okay, so that's extra buffer to make more gifts. Back to 2026, we're going to lose that ability for the club cards. For our club cards, we're still alive. Our club cards are going to reduce in value greatly. So, so why is this important? I mentioned you can't give as much. All right. Well, you know what? Big deal. I'm never going to give more than 7 million. But if you've already used your club card, so some of you on the call now, I know I can see who's here. I know some of you have already used your club card. You already have the punch in it, and you've filed a gift tax. You've done a 709 gift tax return. So what's going to be important? Let's say you made $1 million gift because your house is worth 2 million. You added your kid on, and we talked about it. We said, hey, that's fine in this given situation. Or you passed to your home in trust to some family members, like your children, into an irrevocable trust years ago to avoid Prop 19, and you wanted to utilize the gift exemption, and you did back then. Anyway, my example, a gift was made. Let's just go with the easy one. You put your son or daughter on title of your $2 million house. They own it jointly with you, so you gave them $1 million gift. You filed the return. Now you said take $1 million off my club card. I have $1 million less. Okay, 13.61 million. I really have 12.61 million. So I did that this year. Come 2026, now it's reduced to 7. Guess what? You that million doesn't get taken off the top. You don't have 7, you have 6. So in other words, the value of the club cards, the max value is going to be 7, and you already used the million before 2026. So that means you really only have 6 million left. So that could be impactful if you've given very large gifts in the past. And so when it gets reduced down to 7 million, you might have only 1 million, 2 million, a few million left to gift in your lifetime, which then can become much more significant later. It's also going to be significant for people because their estates might not have been a married couple. Their estates aren't worth $27.22 million now or over it. But certainly in 2026, maybe they have a $15 million estate. You know, they have some, and your estate includes your retirement, term life insurance policies, whole life insurance policies, investment accounts, your home, and your home at fair market value, not the equity in your home. It's the fair market value. So it's not that hard here in Southern California to hit that $15 million mark these days. So if you're at that $15 million mark, that's going to be, that's significant because you know in 2026, you're going to have a taxable estate. What does that mean? That means if you were to die, so you died January 1st, 2026, both you and your husband or wife, and you have a $15 million estate. You have people to give that estate to. You have kids that give it that to. Now you're $1 million over. So that means the IRS is going to tax your estate on that million. The amount is going to jump up from 40% to 45%. It's going to be 45% tax rate. So that means your estate's going to have to pay out $450,000 to the IRS in due date 9 months from the date of your death. And that's going to have to be paid to the IRS. They don't care how it gets paid. They just want to be paid. It's kind of like the mafia. I don't care. You don't pay it, we're going to come to your house and break your thumbs. Well, I don't have that cash. I got to sell some property to do it. We don't care. Those sound like excuses. We want our money. That's how the IRS is going to work. And they're not going to break your thumbs, but they're going to start charging penalties on your estate. And really, it's like they're basically taxing your kids because that's the inheritance to them. So that's how that's going to be a big significant factor. One day you don't have, your kids aren't getting taxed. So if you died December 31st, 2025, not a problem. Died January 1st, 2026, all of a sudden your kids are having to pay $450,000 in my example. There are things that we're going to be able to do in advance of that to prepare to avoid that situation. No, I cannot increase the value of your club card. I can't put more money on that club card for you unless we're talking about you're a widow or a widower, like I mentioned, and we haven't filed that paperwork. That's how I can get you more money on that club card. But outside of that, we have to look at some different strategies. So what you can do to prepare. If you're a person that has your very high net worth, we need to talk about the use it or lose it strategy. We have to start making big gifts before you lose out on the ability to make them. So we need to talk about creating a gifting strategy where we're making a lot of more micro gifts where we don't have to use our club card. And so we're making those $18,000 gifts. We're paying school, we're paying medical bills. We're doing stuff like that. And we're creating a strategy around it. So we're just not doing it willy-nilly. We're creating a strategy around it. We can do things like opening up and super funding 529 accounts. We can do promissory notes to freeze an installment sale. So we can freeze the value of an appreciating property. So we can kind of, what we can do is we transfer property to our children through a special trust. They don't have the money to buy it from us. So we sell it to our kids. So it's not a gift. They don't have the money. So we do it as a promissory note in a special way. So it's set up so the IRS, we can say to the IRS, hey, we didn't just give them the house. We sold them the house. Yeah, but the IRS says they didn't have money to buy the house. Yeah, oh, we loaned them the money. We put a promissory note there. But it has to be done the right way because the IRS is going to say, show me the promissory note. And if it's done incorrectly, they're going to say, this is no loan. This is a gift. In other words, you can't just put a promissory note and say, you know what, I'm going to loan you the money and you don't have to pay me back anything. We're just going to put it in paperwork that was really loaning me the money and you don't ever pay me back. That's a gift. Or if you put the amounts too low, you say, I'm going to loan you money and we're going to set it at a half an interest. I'll give you half a point on that. And you pay me back half a point a year. IRS is going to say that's a gift. That's not a loan. You're not fooling anybody. Or you do it the right way with the right terms, the right interest amount, and your kids don't pay you annually. And you're just kind of like, wink, wink, nod, nod. We're going to put this on paper. We're going to forget when it comes payment time every year that you actually owe us that. Guess what? That's a gift. So we have to do it in the right way to set it up, but we can freeze the value. So if you have a house here in Orange County, or Southern California, you have a vacation home in a really great spot. I was talking to somebody recently. They have a vacation home in Laguna Beach, that they got grandparents got in the Laguna Beach back in the day when it, cost as much as a number one at In-N-Out to buy land in Laguna Beach. They bought it, and it's been in the family. And so they have this wonderful property in Laguna Beach that's just insane. It's worth an insane amount. See that in Balboa Island too, other place locally. Or we're up at Big Bear or Lake Arrowhead, other common places where we've seen it. And that real estate has been in the family. They use it as a vacation home, is worth a lot of money now, but no one really wants to sell it because they like to use it. They get great money. It's good passive income to rent it. So they Airbnb it, they Verbo it. I used to call it VRBO. I don't know about you. I still do, but apparently they want to be called Verbo. So they Verbo it, and it's making good passive income for the family. So no one wants to offload that. Or you just, philosophically, you're like, look, we're landowners. We're a family of landowners. We're going to keep the real estate within our real estate empire in the family, and they're not going to offload it. So then what are we going to do? Because that's worth a lot of money, and that's problematic because now we're going to, when we pass away, that property in Laguna Beach that's $5 million, or maybe it's more because it's right on the beach, 10 million, whatever. Let's just say it's 5 million, because that's not, that's very, very reasonable as far as being a common situation. That $5 million really puts us over the mark. Now we would have had a $10 million estate, but now we have a $15 million estate, and that property in Laguna Beach is going to cause a $450,000 tax bill. And then the kids are going to have to offload investments that they otherwise would have been able to keep. They would have had to drain an IRA and pay, and that's a huge tax consequence there in order to pay this bill, because they don't want to sell the Laguna Beach house. Of course, they can sell the Laguna Beach house and pay the bill, but they don't want to do that. Or, hey, we don't have enough liquidity in our estate, and we're going to have to sell the property in order to pay that bill, and we didn't want to. So what can we do? Because we know we're alive today, it's 5 million. We're going to live another 10, 15, maybe 20 years. It's 5 million then. Now, what's it going to be in 20 years with this on average 4% appreciation rate? So now it's going to be worth even more when we die. So then that's going to be a bigger tax. So now it's now appreciated another million. So now we're at 16 million if we all things considered equal. Now we're just increased the tax again another 450,000. Now it's a $900,000 tax. So you see the problem here. What do? We want to freeze the value. Okay, if I can keep this at 5 million forever, and wonderful. Okay, I've mitigated, done damage control. So we're going to freeze the value of the Laguna Beach house. And we do that by selling the house to your children. And we have to do that with a special trust. We have to do that with a special promissory note. There's a special way to do that, but that's going to be a strategy. We want to use an irrevocable life insurance trust. And that helps replace money back into your estate. If you have a life insurance right now, you say, I got $1 million policy. All that does is increase the value of your estate $1 million. So don't rush out and get a bunch of money and life insurance policies, because you might tip the scales. And I have some clients where this is true. They have $5 million or more of life insurance, and that is increasing the value of their estate, which is making it a problem for 2026. So we got to look at doing it in a special way. We use a special irrevocable trust, and that trust buys the policy. Now it's not counted as part of your estate. So you can buy the $1 million, $2 million, $5 million policies. The special irrevocable trust owns them. They don't count as the value taxed onto your estate. And then when you pass away, guess what? That money, that life insurance money, gets paid out to your beneficiaries who you want, and that will help pay whatever tax you might owe. So in my example, $15 million, we have $1 million policy held in an ILET. You die, your estate's 15 million. So a married couple dies, 15 million. Now the kids owe $450,000. Well, they're getting paid out $1 million of the life insurance. That's where the money's. They're going to use that money to pay off the IRS and still have a little bit extra left over for them. So great strategy there. Transfer and death deeds. Real quick recap here. You can put a beneficiary on a deed. All right, that's what a transfer and death deed is. You couldn't do it for many years in California. Now you can do it. Those of you that lived in other states like Texas or Arizona know these as ladybird deeds. So you're putting a beneficiary on a deed, and you're like, great, did all this work with you, Kevin, for a trust. All I needed to do was put a beneficiary on my deed. Or I don't need a trust now. I'm just going to put a beneficiary on my deed. I can avoid probate that way. Maybe if it's done right. These things are very technical and the law keeps changing. And guess what they changed? They changed the law even more to make it more technical. So you can try to do this. If it's done wrong, then that beneficiary, that you're going to get X'd out on a technicality. So if there's a technical issue, you can't fix it because you died already, and that's when it's going to get found out, and then that house is going to go through probate. It's not going to go by way of beneficiary. So just know the takeaway is there's lots of rules to do it the right way in making the gift or making the designating the beneficiary, and then there's a lot of rules in how that beneficiary takes it over. And so that's the big update, is they made some extra rules on how the beneficiary takes it over. So mom and dad put son, their only son, as the beneficiary of their house. And this is really geared toward people that are like, oh, I just have a house and a couple bank accounts. I don't need to do this complicated trust thing. I'm just going to put my son, my only son, on my deed as a beneficiary. Now they do that. They said, we don't need a lawyer to do that either. It's just paperwork we can download from the internet, and they do it incorrectly. Now that couple dies and the son comes in and says, hey, I got the paperwork that said there's mom and dad did a transfer and death deed. I just get it, right? It's mine. Sorry, it was done incorrectly. You have to go to probate court and do a probate. What? And because your parents didn't really have much money, with the probate fees on top of that, you're going to probably have to sell the house to pay the probate fees and not get the house. Or not get the full value of the house. New rules now say, let's say mom and dad did it right. Maybe they used a lawyer. In the right circumstances, we'll help people do this. And it's done right on the front end. Now on the back end, you have to go and make certain disclosures. Maybe you're not the only child. Maybe you have a few siblings. Well, you got to go out and tell your siblings and file notice with them that mom and dad made you the beneficiary. You had 3 siblings, one of them died, and they had 4 kids. Well, you got to notify your 2 other siblings and your nieces and nephews. Your nieces and nephews are actually all minors, so you can't just notice them because they're minors. That doesn't count. You have to notify their legal guardian, and you have to figure out who that is if it wasn't maybe the surviving spouse. Well, what if you lost touch with them? I don't know where they live. Well, guess what? The law doesn't care. You got to go find them, and you have to show that you have made attempts to find them. So if you actually can't find them because they fell off the face of the earth, then you have to show that you at least made reasonable attempts to do that. And all this time, property's not yours. So and you're like, shoot, market's hot, I could sell it. Can't sell it, property's not yours. So these transfer and death deeds are complicated. They're technical. You can make mistakes in filing them. They actually can cause a longer period of time to transfer it to your loved one after you die. If that was in a trust, would have happened like that. Not a problem. So those are big issues. There really is very specific circumstances in which this works. Again, you want a deeper dive? Let's do a webinar. Come in the office. We'll talk about it. Change in Medi-Cal. Medi-Cal, now there's no limits on assets. Okay, so that means you can be a billionaire, hypothetically. You can be a billionaire and still get Medi-Cal. Well, wait a minute. I read somewhere that you can only have $2,000. Well, guess what? That's gone. It's not $2,000. It's not $130,000. 3,000. These are all numbers you'll see out there if you do any search on the internet, because the rules have changed in California and they're different in other states. So all that information you're pulling in the internet, you're asking AI to pull. It's a lot of that's from different states are now old laws in California. In California now, they're not going to look at assets you have. So it's not just the house you live in. You can have a house and a vacation home. Doesn't matter. Like I said, you can have $1 billion in assets. Doesn't matter. Of course, if you are a billionaire, you probably are getting a lot of income every year because you have assets that are paying out rental income to you or dividends in the stock market. You're getting income. Income still counts. So a billionaire is not going to qualify for Medi-Cal. Let's put it that way. You're going to be income ruled out. You're going to be income disqualified. And just because you have you need Medi-Cal or someone you know needs Medi-Cal, we still have to look back in time to see what sort of transfers they made over time. So while they even if there's no asset rule, there's still a transfer penalty, and that transfer penalty will effectively end July 2026. So there's still some groundwork. There still might be some penalty periods if certain levels of gifts were made. So if you want to qualify, you have questions about qualifying for Medi-Cal, let's talk. Just know that the good news is more people can qualify for Medi-Cal now because they're not disqualifying people for how much they own. So like I said, bad news is look back still exists. Income still an issue that we need to talk about. Doesn't mean if you get income that you're not going to qualify. It just means that we have to do some more work to get you to qualify. We were doing that before. We were doing strategies to maneuver legally, navigate around the rules to get people qualified. We're going to still do that. It's just going to be focused on income now. So this is just for Medi-Cal. So if you or a loved one or someone you know is receiving SSI, supplemental security income, because of a disability, then it's not because of a disability that they have got on the job and they're getting paid SSDI. That's something different. But it's because of SSI. They cannot have more than $2,000 of assets. That is still a rule. If they do, then they're going to lose the SSI benefit. And with the SSI benefit, they're going to lose the Medi-Cal healthcare benefit that goes along with that, which is the real benefit there. The SSI benefit financially, not so much. It's a small amount, a little over $1,000 a month. A lot of people are getting less than that for a variety of reasons. So it's a small financial stipend, but it opens the door for Medi-Cal healthcare, which is very good in California. So you don't have those medical expenses or expensive healthcare costs. So that's a key for some people. So they want to keep their SSI benefit. Also, if you are a veteran or is a surviving spouse of a veteran, you might have asset rules when it comes to receiving those benefits like aid in attendance or survivor's pension. Those have not changed. All right. So they're still going to be looking at your net worth in those situations. So asset amounts are important. Income amounts are important. Again, any questions on this situations? You're like, I want to explore Medi-Cal. I think mom and dad need it. Or my husband or wife needs it. Can we qualify for it? Do we qualify for it? Let's have a conversation. You are a veteran that served during a wartime period, or you're a surviving spouse of a veteran who served during a wartime period. Let's talk to see if you're currently eligible, or how can we get you eligible for aid in attendance, which could be a payout of almost 30 grand a year, to a survivor's pension, which would be a payout of almost 20 grand a year. So real money that's out there. Corporate Transparency Act, super important here. If you are the 4 categories that I mentioned, you are a business owner, you are very clearly a partner in a business. You own it 100%, half. You own it with your husband, wife, or best friend, or just your business partner. You have a corporation, an LLC, a limited partnership. Guess what? You have to file a special report with the United States Treasury's financial FinCEN, the Financial Crimes Enforcement Network. There's a new law, Corporate Transparency Act, which was passed to give the U.S. Treasury and the federal government the ability to collect information because they're trying to battle and fight money laundering from criminals and terrorists. So a lot of people are setting up these shell corporations and funneling money through them, and that's funding terrorism, to both domestic terrorism and international terrorism, and just plain old criminal stuff. So they want to put a clamp down on that. And so the information, all this stuff that you have to report is out there, but a lot of it resides in different government agencies. Some of it they don't have. We're talking about foreigners or people that are just flying under the radar. This gives them the ability to collect that information, or at least put the information in one spot for them. So for a lot of us, this is information the government already has, where we live, who our name is, when we were born, our legal name, if we go by something else. If we've started a business, they already have the business name and address. They know they have a tax ID number. Just different agencies have it, right? They're not even asking for a social security number for an individual. So they're just saying, hey, we need all this on a form that we are going to now keep. You're making it easy for us to track this down. So for people that are privacy inclined, really, you're not giving up any more information than the government already knows about you. So it's really not as big of a deal as it sounds from a privacy standpoint, but some people are just privately inclined, or they don't like big government. They want to say, government, stay out of my life. The problem is that it's here. You got to do it. And if you don't do it, then there's penalties. So if you you're a beneficial owner, someone who has to report if you own 25% of a business or more, or if you have a controlling interest in the business. So let's say you own 10%, but you own 10% of the voting shares, and that's a majority percentage for some reason. Then in that situation, you have to report. Even though it's less than 25%, you actually have a controlling stake in the business. So you have to report. Trustees of trusts have to report if it's an irrevocable trust. Beneficiaries of irrevocable trusts may have to report. What's clear is if you have a revocable trust. So if you work with us and we set up your revocable trust, and you're married and you're still married and both of you are still alive, we don't have to report your trust. Okay, it's not for revocable trusts. But if we set up your revocable trust and one of you's passed away and it was set up in a way that now there is an irrevocable trust, we got to report that irrevocable trust. We got to report you as the trustee on this form. And if there are other beneficiaries of that irrevocable trust, like your spouse's children, that maybe your stepchildren, or you added your children in on that irrevocable trust while you're still alive, then we have to report them too. All right, so there's a lot of reporting going on. If you are a trustee of someone else's trust, someone else died, and they named you as the trustee, that's an irrevocable trust. We're going to have to report that trust, you as a trustee, and the beneficiaries of that trust. So it goes beyond just business. But certainly I made an investment. I gave $100,000 to a buddy of mine who was investing in a new restaurant chain or whatever franchise. And as a result, I got 25%. Well, you got to report yourself as a beneficial owner. And if you don't, then you can get in trouble. So these are real things and how they come up. And when you're reporting the business, you got to report everybody else. So when you file on behalf of the business, you got to list all of the beneficial owners, not just you. You have to report everybody on there. So this is an important situation and a lot of information. So we got to get that going. But not all businesses have to report. So we have 23 exemptions plus one. So these are the 23 exemptions here. Again, we can get this information to you. Just know that we have to look at it. So CPAs are looking at number 15, go, whoo, lucky me, I don't have to report. Kevin's looking at it going, shoot, I got to report. They don't put lawyers on here. Lawyers are not exempt. So we got to look at this. If you're inactive, you might have to still report. So number 23, oh, well, I dissolved my business this year. I don't have to report, I'm inactive. No, you still have to report because you were active at some point during this year. So sorry. So, and there's other definitions of inactive. If your business is doing really well and you're making more than $5 million in gross sales, you don't have to report. All right. So McDonald's is not going to have to report. Google is not going to have to report. That you don't have to worry about that. But if you're like me, you're like a lot of people, you're a small business owner, this is something that's going to affect you. There's filing deadlines and penalties. Don't be late. Don't be late. $500 per day, fine, up to 2 years in prison. This is the federal government. They don't play. There's no intent. There's no knowledge defense. You can't say, I didn't know about this. I had one client say, well, was someone going to tell me? The government is just making these announcements out there. And, if you hear about it, great. If you don't, that's not a defense. It's not a defense to say, well, I didn't mean to. I'm only finding out about it now and I'm late. Well, we don't care. You should have known about it. Like I said, federal government doesn't play. There's no intent crime. So now they've come out and said, like, look, if you didn't know about it, we're not going to shove you in prison. We are going to penalize you, though. We're going to bill you a lot of money, but we're not going to throw you in prison. But if you do it on purpose, now that you find out about it, and we can say that you knew about it and you willfully didn't file anything, yeah, we're going to throw you in prison. And like I said, they don't play. So look, just from a standpoint of all you on this, a lot of you I know, I'm not concerned about you going to prison, but I got to tell you about that because that is on the books. Legally, they could. I'm more worried about how expensive it's going to be for you. When you calculate the $500+ a day, that compounds. So if you started a business and it was in before this year, and it was in business this year, we have to file these reports no later than December 31st, or then they start charging you. If you created a business this year, you have 90 days from the date you started the business, and starting the business means the date that it was stamped by the Secretary of State of whatever state you filed in. Again, this is not a California law, this is a federal law. And then next year, you're only going to have 30 days once you create a business. All right. So things for us to know about. So many of you who are small business owners now, hey, look, we have until December 31st to do this. We're helping people do this right now. You got to get in front of it. You're like, hey, it's August. I got time. Time moves fast. And you don't want to be calling in and on December 31st and saying, I need help, because we might not be able to help you. In fact, our office is probably going to be closed on December 31st. Or if it's December 1st, we might say, hey, we're going to try, but we're so backloaded with all of this stuff, because humans are humans and they like to wait till the last minute. We're program procrastinators. Get in front of that. Get on the early bus here. Let's help you. If you want more information, go to this website. The government does a decent job of explaining it. But beware of scams, business owners. There are scammers out there taking advantage, trying to pose as the U.S. Business Regulation Department. No such thing. Also, you might hear that, oh, this is unconstitutional. I'm just going to wait until the law and see how it plays out in the courts, and I'm not going to have to file. So I'm just going to wait around, because there's this case in Atlanta, and they ruled in favor of the business owners. And so on the grounds of unconstitutionality, this law is unconstitutional, not going to file. Guess what? That case limited to the businesses were in that small class of businesses in that lawsuit, limited to the plaintiffs. Doesn't apply to anybody else. They are appealing it, and the 11th Circuit's going to rule on it, but the ruling is going to be contained to the facts in that case. So if all the 11th Circuit, if it's a win for those businesses, they're just going to affirm what's already the law now. Those particular businesses don't have to file. If they overrule it, then it doesn't matter. They're saying it's not unconstitutional. They haven't come out with a ruling yet. It's August. Guess what, people? This law is going to stay in effect at least for the rest of this year. Let's get the paperwork in, right? Okay. We're getting close to the top of the hour. And so there's a few other things I want to leave you with. Like I said, I can talk. Laura's like, look, I know, we'll do it in another webinar. So when we do revocations, or we make amendments to a trust, we have to be careful, because the law has changed in this regard due to a case. Now, this isn't the law as a statute, but the Supreme Court of California decided and said, you can change change your trust, and the terms of your trust will decide how it is you can make those changes. So basically, like a contract, the trust says, if you want to make an amendment, this is how you make an amendment. And so there's that way. And then there's the way that in the law where the legislature said, if you want to make an amendment, this is how you make an amendment. So the legislature made it very kind of easy and said that any writing signed by a person to make an amendment to their trust counts. You don't have to have a notary. You don't have two witnesses, just any writing, except for a will, any writing, literally go write on a napkin. I am my dying breath on the napkin in the hospital. I'm writing down, I want to change my trust and change the trustees, or I want to disinherit this person, or I want to add this person. We all know the stories. We hear that. They happen. Life's stranger than fiction. Trust me. So those situations, the law said, hey, that can count. That's count as amendment. The trust says, hey, this is the way you can make an amendment. you have to do X, Y, and Z. You have to write it down, you have to get it notarized, and then you have to give notice to all the beneficiaries. If you don't do that, then it's not a valid amendment. Well, the Supreme Court said, and there's a contrast. So the napkin, now of course the people that are benefited said, hey, Uncle Joe, when he was dying, on the napkin said I was going to be a beneficiary, and I was the only person that was going to inherit. He changed his trust. Of course, Uncle Joe's kids are going to say, no, that wasn't done by the terms of the trust. The Supreme Court said and had to be like Solomon and decide this. And they said, hey, look, the rule is that the napkin still can be a valid way to change the trust. The trust has to say, this is the only way you can change the trust. So unless you have the exclusivity in it, unless you say only, then both ways can work. So the new friend, the caregiver, not the caregiver, that whole other thing we do. Hey, Laura, we'll do a webinar on caregivers making gifts. That's an important one. But the new paramour, the long lost relative, or the child that all of a sudden gets cozy to the uncle or the niece or nephew right before death, and they have the napkin that says they get everything because the napkin says I amend my trust. Guess what? That napkin rules the day. But if the trust said only they have to do X, Y, and Z, napkin loses. So that's important to know. So we're making changes to your trust. We need to look at, if you said, hey, I don't like the napkin deal, we got to adjust your trust to say, this is the only way that we do things around here. You have to do X, Y, and Z. So those of you out there that don't like the napkin scenario, let's talk. Directed trusts. Just know that we can do something called a directed trust. We can create a shield on your trust, somebody to watch over your trustees to make sure that they're following what they're supposed to follow. And I'm not talking about a judge. I'm talking about somebody else that you appoint or some other institution that you appoint to monitor your trustees to make sure that they're doing the right thing, or to make your trust flexible and saying, hey, we can actually change the trust. You died or you're incapacitated. Normally your trust is irrevocable. But hey, it would be really great if we could have made this change for whatever reason. We want to add a trustee that would be better, or we want to move the trust assets to Nevada so we don't get hit with California income tax. But the trust doesn't allow for that. It would be really great if we can insert that rule and term in the trust, or the trust allows for the napkin to amend the trust. We got to get rid of that, but the trust is irrevocable now. How do we change that? Well, mom or dad's in the nursing home and is incapacitated because they have dementia. How do we change that? Well, if we had a trust protector and a directed trust, then we could do that. The trust protector could be given powers to say, I'm going to allow this particular change to happen, even though normally an irrevocable trust can't be changed. So we're allowed to do that in California now. Great new opportunities to amend and update your trust for those scenarios. If you don't have a trust protector, which you really hear in your trust, then let's talk. For business owners, just know buy-sell agreements, strategies have changed. And then this is the last slide for today. Buy-sell agreements have changed. So if you're a business owner, you might have bought key man insurance because when you die, you want the company to buy back your shares or membership of the business so that it could pay out to your family because there's value there. Example, you have a company, we'll just say it's worth $5 million or it's worth $10 million. And so it's you and a partner in this company. You've worked it for the last 25 years. You built it up and you're still working, and you say, look, if I pass away now, my wife doesn't want to be involved in business with my partner, doesn't want to run it. My kids don't want to do it, but I want them to be able to extrapolate the value of it. So we get a key man policy. So basically the company owns the policy on me. And so when I die, the policy pays $5 million to the company. So the company has cash money to buy out my membership or shares in the company to pay my family, my beneficiaries. Sounds great. That's really good business succession planning. The challenge now is that they had this new case that just came down in June, Connolly versus US. And I don't have the time to tell you all the facts about it, but it is basically this example. And what they said is, well, guess what? That $5 million policy that the company owned is actually going to increase the value by 5 million, because when it pays out, now the company's got $5 million in cash, even though they don't have it for very long. They do have it. And so now the company is valued at $5 million more than it was before. Before the day you were alive, it wasn't worth, it was worth 5 million less. The day you died, now it's worth 5 million more. And you have ownership of half of the company. So your estate just jumped up in value $2.5 million because you died. Even though the policy didn't pay out to you and your estate, it paid out to it paid out to the company. And then, of course, pays out $2.5 million to your estate. That's a problem, because if you're on the cusp, if you have now in 2026, if you're hovering at a certain amount, right? Your half of community property is at 6 million, and now you get paid out. It's your separate property, this business, and it now pays out $7.5 million to buy your shares out. The value of your company now boosted up by 5 million. That alone is going to put you over the edge, because you're half of the company. That half of the key man insurance policy, $2.5 million, is going to put you over, never mind the value of the other business. So these succession plans are going to trigger estate tax. So we have to look at some more detailed strategies, different strategies. If you have a buy-sell agreement, let's talk, because we're going to have to restructure it. Trustees, let's talk, because there's new rules in being a trustee and things that you have to follow. This is important. This is for everybody. So anybody who is a fiduciary, who's a trustee, executor, new rules for us to follow. So we have to look at that. And if you are a trustee because the person in the trust has dementia and is incapacitated, there are new things that you need to know and do. You don't want to run afoul of them, because you might become personally liable and get sued by beneficiaries and personally owe the money, not the trust, but you personally. So let's talk and find out the rules. New healthcare directive, the rules and healthcare directives, just know if you want a do not resuscitate, we have to do it in a certain way. There's a special form for that and a special way we go about that. If you hear about DNR tattoos out in the universe, I was recently introduced to this. Not a great idea. Okay, maybe do it in addition to doing the forms. So this is saying, hey, I do not resuscitate on your person. So it's just kind of like writing your phone number on a kid's hand, and you're going out to Disneyland in case they get lost. Same with the DNR tattoo. But that's not going to be enough. It's going to be confusing. Again, we can talk a little bit more about that. But there's a new form for DNRs. We're handling dementia in a different way in healthcare directives. There's more things to consider. We're putting additional terms and options in directives. There's actually a new recognized dementia directive, and also a more recognized mental health directive. So if you struggle with mental health, you have a diagnosis or know somebody that does, we might want to look at a mental health directive for you or that loved one. That details are a little more detailed. Can they be institutionalized? Do they? What are the powers that the agent has to do that if it's necessary, and so on and so forth. With dementia, what do you want to do if you have severe dementia and you stop eating? You want artificial nutrition, be force-fed, spoon-fed. What if you contract cancer? Would you want your loved ones to pursue treatment or not? Things like that. Those are in the dementia directives. So that's the presentation. I missed my mark on time. Next time we won't sit around and wait for so many people to show up, right? We'll just start the engines and go. Thank you for sticking around for an hour and a couple minutes. If you have questions, we're going to hang around and answer questions. You're welcome to stay and listen to the questions and answers. And certainly if it's your question, please stay. I will answer it right now. But for those of you that have to get back to work or start your weekend early, thank you for coming. I really appreciate you all.